Legal Terminology Module. There are 7 lessons with their corresponding desired objectives to be achieved by participants within this module. At the end of these short lessons, participants should have gained a basic understanding of the meaning and usage of legal terms in common legal situations and functions. Of course, we have to have a disclaimer, right? All the information provided in these short lessons is publicly available and provides interpreters working in the legal field with an understanding of basic legalese and other commonly heard terms. This information is not intended to be construed as legal advice. Participants will also be provided resources to complete the individual assignments and are encouraged to use the same to enhance their personal glossaries by incorporating the legal terminology used in these lessons so they can interpret and/or translate them correctly into their working languages. Lesson 2. Common Criminal Courts Specific Terms. The objective here is for participants to gain a basic understanding of commonly used English legal terms in criminal courts and how to conduct effective research to interpret or translate them into other working language. As this slide indicates, the 50 states, the District of Columbia, Puerto Rico, and Guam reported a total of 84.2 million incoming cases for 2016, or about 2.1 million fewer cases than were reported for 2015, which is not shown. Just over half of all 2016 cases, 53%, were reported in the traffic violations category. These actions typically consume far fewer judicial and court resources than the remaining 4 categories of criminal at 21%, civil at 18%, domestic relations 6%, and juvenile less than 2%. Criminal cases are the second highest cases after traffic violations, thereby reaffirming the need for interpreters to have a well-established command of legal terminology. However, interpreters should not forget that there are many other legal settings they might find themselves working in. An interpreter could also be required in non-court communications, such as assistance at the clerk's office or counter in the courthouse, court-ordered events, such as mandatory arbitration, mediation, court-ordered medical evaluations, etc., probation, for example, pretrial interviews, or any situation the court may deem appropriate. Each state has its own court system and set of rules for handling criminal cases. Here are a few examples of differences between the state and federal criminal processes. The title of people involved. State cases are brought by prosecutors or district attorneys. Federal cases are brought by United States attorneys. State court trial judges have a range of titles, but federal judges are called district court judges. Federal magistrate judges are used in federal cases to hear initial matters, such as pretrial motions, but they do not usually decide cases. The use of grand juries to charge defendants is not required by all states, but it is a requirement in federal felony cases unless the defendant waives the grand jury indictment. States and the federal government have laws making certain acts illegal, and each jurisdiction is responsible for setting punishments for committing those crimes. A state may punish a certain crime more harshly than the federal government, or vice versa, but a defendant can be charged and convicted under both systems. The federal rules for criminal cases can be found in the Federal Rules of Criminal Procedure, which governs all aspects of criminal trials. Each state has its own similar rules. Once the criminal process starts, there are many steps involved, which, of course, means hundreds of legal terms. Please remember that a criminal case consists of a number of phases, from the initial arrest to sentencing and possible appeal. The following legal terms regarding the process would most likely also come up during the pretrial phase of a criminal case. While there is no way to include all the legal terms one might hear in a criminal proceeding, here are some of the most commonly heard legal terms that an interpreter will need to know in both working languages. At the beginning of the process, the warrants are generally issued by a judge for one of three reasons: to arrest someone suspected of a crime, to search a suspect's property, usually a home, vehicle, office, or desk, in order to obtain evidence, or if someone has missed a court date. Just cause is required for a judge to issue a warrant. There are different types of warrants. For example, search warrant, which is used to conduct a search of your residence. It permits law enforcement to legally enter your home and seize any of your property they suspect of being potential evidence. Arrest warrant, which is issued when law enforcement officials or grand jury feels there is probable cause, that is, a reasonable belief something illegal has occurred, to suspect you've committed a crime. It is a legal document that orders the police to arrest and detain you. A bench warrant is a more common warrant than an arrest warrant. Typically, it's issued when someone fails to appear for their court hearing or fails to answer a subpoena. A quashing warrant. The defendant or defendant's attorney may schedule a hearing to quash a warrant, either in person or by telephone. The warrant will not be stayed or quashed, and the defendant will still be subject to arrest on the warrant until the defendant has appeared in open court and the judge has quashed the warrant, unless otherwise authorized by the court after a telephonic hearing. Other terms you will also hear are arrest, reasonable suspicion, Miranda warning, and arraignment. The initial appearance. In criminal law, the hearing at which a judge determines whether there is sufficient evidence against a person. Pleas. These are the defendant's statement pleading guilty or not guilty, or perhaps an Alford plea. Bail or bond. A security deposit, usually money given to release a defendant. Citation. A court order or summons that tells a defendant what the charges are. Diversion. Instead of going to jail, the defendant goes to a rehab program. Misdemeanor. A crime that can be punished by up to 1 year in jail. Felony. A serious crime that can be punished by more than 1 year in prison. A complaint is a legal document that usually starts a criminal case. A count is each separate charge or statement in a criminal case. Preliminary hearing. The hearing available to a person charged with a felony to determine if there is enough evidence for trial. Probable cause. A good reason to believe that a crime has been committed. Information. A written accusation charging a person with a crime. Indictment. A formal charge by a grand jury saying there is enough evidence that the defendant committed the crime. Deferred. A deferred judgment means that although you plead guilty, no conviction will go on your actual criminal record. Continuing on with the legal terms interpreters would need to know, here are prosecution, the party by whom criminal proceedings are instituted or conducted. Plea settlement, an agreement between the prosecutor and defendant whereby the defendant agrees to plead guilty. Discovery, the gathering of information before a case goes to trial. Subpoena, a request for the production of documents or a request to appear in court or other legal proceeding. Waive, to voluntarily give up a right or knowingly giving up a legal right, such as a speedy trial, a jury trial, or a hearing on extradition. Continuance, the adjournment of an action pending in a court to a later date of the same or other session of the court. Motion. Motion to suppress, motion to change venue, a procedural device to bring a limited contested issue before a court for decision. Now we get to legal terms interpreters here during the trial. Jury panel, a committee appointed to judge a competition. Voir dire, the process of questioning potential jurors to choose the people who will decide a case. Peremptory challenge, a right in jury selection for the attorneys to reject a certain number of potential jurors without stating a reason. Bench trial, a trial by judge as opposed to a trial by jury. Jury trial, a trial by jury as opposed to a trial by judge. Interpreters will also hear trier of fact, someone who determines what the facts are during a trial. Opening statement, the first occasion that the trier of fact has to hear from a lawyer in a trial. Burden of proof, the duty of a party in a trial to produce the evidence that will prove the claims they have made against the other party. Beyond reasonable doubt, evidence that is beyond reasonable doubt is the standard of evidence required to validate a criminal conviction. Hearsay, a statement by someone to a witness who, while testifying in court, repeats the statement. Objection, type of protest made in court or during a deposition against a witness's testimony or a piece of evidence. Sustain or overrule. When an objection is sustained, the judge has determined that it is a valid objection. When an objection is overruled, the judge has determined the objection is invalid. Rebuttal. When one party makes an assertion about something, another party may make an argument against it. Directed verdict. A ruling entered by a trial judge after determining that there is no legally sufficient evidentiary basis for a reasonable jury to reach a different conclusion. Dismissal. A ruling by a judge that the plaintiff's lawsuit is thrown out. Closing argument. The concluding statement of each party's counsel reiterating the important arguments for the trier of fact, often the jury, in a court case. After receiving instructions from the judge, the jurors as a group consider the case through a process called deliberation, attempting to agree on whether the defendant is guilty or not guilty of the crime or crimes charged. Deliberation is the first opportunity for the jury to discuss the case, a methodical process that can last from a few hours to several weeks. Once the jury reaches a verdict, the jury foreperson informs the judge, and the judge usually announces the verdict in open court. Here are some common legal terms during jury deliberation. Jury instructions, directions that the judge gives the jury right before they decide a case. Sequestration, in the context of trials, the isolation of a jury from the public or the separation of witnesses. Jury deliberation, the phase of a civil or criminal trial in which the jury meets in private to discuss the evidence presented in court and decide whether the defendant is guilty or not. Verdict, a jury's or a judge's final decision. After the verdict, the legal terms will then refer to the sentence delivered. A criminal sentence refers to the formal legal consequences associated with a conviction. A lesser type of sentence might be probation, for instance. However, for more serious crimes, the sentences include long-term incarceration, life in prison, or the death penalty in capital murder cases. Other legal terms heard during the sentencing phase can also include fines, short-term incarceration, suspended sentences, which only take effect if the convict fails to meet certain conditions, payment of restitution to the victim, community service, or drug and alcohol rehabilitation for minor crimes. If the jury returns a verdict of guilty, the trial judge imposes a sentence and the defendant may appeal his or her conviction. With a guilty verdict, the defense is allowed to file a motion for a new trial. If the trial judge sustains this motion, a new trial will take place. These are some of the terms frequently used in a post-trial criminal procedure. Appeal, When someone that loses at least part of a case asks a higher court to review the decision and say if it's right. Brief, a written statement that each side gives the court to say what the court should decide that they are right. Oral argument, the part of the trial when lawyers summarize their positions in court and also answer the judge's questions. Affirmed, in appellate courts, it means that the decision of the trial court is correct. More legal terms during the post-trial phase would be remand, when an appellate court sends a case to a lower court for further proceedings. Revoke, to change or take back. Parole, supervised release of a prisoner that allows that person to serve the sentence out of prison. Habeas corpus, the name of a writ used to bring a person before a court to decide whether that person is being unlawfully denied his or her freedom. Before we continue learning more legal terms, spend some time researching on the internet and identify a legal equivalent in your working language for at least 25 of the more than 70 terms previously discussed in this lesson. Use the handout 2A provided to write them down. Here are some additional legal terms that interpreters frequently hear. Chambers, a judge's private office. Pro bono, legal work done for free. Pro se, a person who presents their own case in court without lawyers. Indigent, a person who is poor, needy. Statute of limitations, a law that says how much time you have to file a lawsuit. Conviction, when a judge or jury finds a criminal defendant guilty. In most states, first-degree murder is defined as an unlawful killing that is both willful and premeditated, while murder in the second degree is defined as an intentional killing that is not premeditated or planned, nor committed in a reasonable heat of passion, or a killing caused by dangerous conduct and the offender's obvious lack of concern for human life. Quashed. To quash means to overthrow, to vacate, to annul, or make void. Larceny, stealing or theft. Expungement means an official and formal erasure of a record or partial contents of a record. Rap sheet. A rap sheet is a written summary of someone's criminal history. Exclusionary rule, the rule preventing illegally obtained evidence to be used in any trial. In Lesson 2, the key points to remember are: there are English legal terms and phrases that are commonly used in criminal proceedings. Interpreters are expected to not only understand what the English legal term means, but also be able to render said term or phrase into their working language. Individual activity. Identify a legal equivalent in your working language for the following 18 statements. Conduct any needed research, including internet searches. The statements are included in your handout 2B. End of Lesson 2.